Any mention? Please, Lordship. Lordship, I beg to mention item number 7. Lordship, I pray for 2 weeks' time, Lordship. In this matter, Your Lordship, a talk of settlement is going on with the government, Your Lordship, regarding payment of excise
My
duty.
lord, I have been informed that there is some settlement talk going on between the respondent and the petitioner.
Item 7 on the request made on behalf of the petitioner. This is matter after 2 weeks. 2 weeks? We all right?
My lord, 2 weeks.
Obliged, Lordship.
May please, Lordship.
Yes.
Item number 5 on the joint request, Your Lordship, because here I am for the petitioner.
Yeah, for respondent 3 and 4, Your Lordship.
Why are you asking for adjournment?
Actually, one of the advocates is not available. It seems that's why
One
we have make a
advocate
request. Mr. Day is not available.
Yes, sir.
You are there.
I'm there, but
Let this matter be taken after 2 weeks, Your Lordship.
5 on the joint request after 2 weeks. Okay. Yes.
Much obliged.
much less, Lordship.
Lordship, I beg to mention item number 4. Lordship, we are yet to obtain instructions in this matter, so we are praying for.
What is this matter about?
It's pertaining to reservation of post.
What instruction was required to be taken here?
With regard to the notification in respect of the disability matter, how much percentage is reserved for the disability?
There's an order passed by this court.
No, my lord, by Honorable Chief Justice.
Acha, this was listed there and it came back again.
My lord.
So just let the matter be called.
Yes, Lordship. Lordship, we are yet to obtain instructions in this matter.
Just we will see what kind of instruction is needed.
Yes, Lordship.
And then we will accordingly grant you time if at all it is needed.
Okay.
All right.
Please, Your Lordship, I beg to mention item 8, 9 and 10.
Item 8, 9 and 10.
My lord, these are connected matter, my lord.
Yes.
In fact, my lord, the main writ petition, it's part heard now, my lord. So these people are all a party to the case.
Main
in
writ
which,
petition means?
my lord, there is a writ petition pending in which, pursuant to that, my lord, some FIRs were filed against these people who have before lordship. So that matter is yet to be decided by court number 3, my lord.
Then if that writ petition is decided, then what would happen to these matters? What would be the fate of these matters?
My lord, I believe this matter will be still going on because, my lord, it appears like through the argument, my lord, case is being made out.
What is the writ petition about and what is the...
Well, it's regarding like embezzlement of the funds of the school, my lord, the teacher's salary,
What is the
appointments.
relief sought in that writ petition?
My lord,
What is the relief sought in that writ petition?
my lord, they are challenging the termination, non-payment of salary, and these are the principles of the school
These are criminal
headmasters.
matters,
My lord,
not
yes.
relatable to those.
No, my lord, person to the criminal case was filed against them, FIR was filed for them, my lord, and removing them from service. And
That is
misuse
why
of
the
money.
question is that what bearing the disposal of writ petition will have in these petitions.
My lord, in that there are 7 petitions I have filed, Lordship. I am the petitioner.
He's a petitioner, my lord.
You are the petitioner.
Here, Lordship. Here, against the petitioner, we lost some complaint against the, about the mismanagement of school fund, Lordship.
And termination.
Then, because of that, we were terminated, Lordship. Then, this proceeding arises out of the case from the Lokaयुक्त, Lordship. And Lokaयुक्त has directed the police to register the case. Accordingly, the case was registered against the petitioner and he was arrested and now he is facing the trial, Lordship.
So he has come before for caution of those my lord, proceedings.
This is with regard to embezzlement of
School funds.
school fund. And because of the complaint, we were terminated. The teachers were terminated. The teachers who lost the complaint. And that separate petitions pending different.
You are a respondent here in this.
Here I am
He responded, my lord. There is a petition in the writ.
Okay, and that matter is part heard.
Tomorrow, my lord. It's part heard and it's coming tomorrow.
This is a criminal proceeding. This is a
So it means there is a joint prayer for adjournment.
Can be.
This also. Just 8, 9, 10 also just say on the joint prayer made by the parties. Is this matter after 2 weeks? 2 weeks?
2 weeks.
Okay.
May it please, Your Lordship. Lordship,
Yes.
I beg to make a mention of item number 11, Your Lordship. Lordship, I'm appearing on behalf of respondent number 2, Your Lordship.
Item number 11.
Item number
Number
11.
2 is private respondent.
Yes, Lordship.
Yes.
Your
Mr.
Lordship.
Roy, what is the matter about?
Your Lordship, this is the matter regarding the breach of contract, where they have lost an FIR, tried to give a criminal color to a civil disputes. So we have filed 482 challenging the charge sheet.
That has been matter has been charge sheeted.
Yes, Your Lordship.
Trial is going on.
Evidence at the evidence stage, Your Lordship. Trial is going.
So what is to be done today? Praying for a grant of time.
No objection, Your Lordship.
When do you want it?
After 2 weeks, Your Lordship.
After 2 weeks on the request made on behalf of the private respondent. Yes.
Much.
Highly
You're also there, Mr.
May it please Your Lordship, I beg to mention item number 3. Lordship, in the missed case, we are supposed to file a show cause. However, we're still waiting for the
Let the
petition.
matter come up. Let the matter come up.
Item number 1,
Yes, what is your difficulty?
Your Lordship, in the miss case, we are supposed to file a response, a show cause against the application.
You have not filed. You are not filing.
We're not ready, Your Lordship, because we are still
So
waiting
we'll
for the
allow their
petition.
application since you are not filing.
No, we'll be filing. We'll be filing. We will be filing, Your Lordship. We grant some more time.
Only
For us.
submission is that this matter is
That is the only submission. You will not make any other submission.
Just I'm explaining what has happened in the past. What has happened in the Lordship, in 2018 there was an order whereby my affidavit has been closed. Thereafter, Your Lordship, I was not aware because there was another counsel in the matter.
Whoever it is, party was there.
Then she joined the judicial service in Jaintia Hills Autonomous. Thereafter, Your Lordship, the matter came up for hearing. We've been appearing regularly. My learned friends here never brought that into notice because I was not aware also. The matter went on for several years. Those several adjournments were sought for. On a particular date that was 4 weeks ago, the matter came up for hearing. We were all ready. Then my learned friend read the order that my rights had been closed.
They are sleeping all along. Suddenly,
Not
they
exactly
wake up.
sleeping. I've been appearing throughout. So, Your Lordship, was also the suggestion that
Whatever
we
it
file
is,
an application for.
if there exists an order, an
Absolutely.
order sheet,
Then I have filed that, Your Lordship, that was 3 weeks ago. So now this is the third attempt, they've been seeking for time. Though ultimately, Your Lordship, it's Your Lordship discretion whether to allow me to participate or not.
yeah, but then you have to hear them, isn't it?
Absolutely,
You have
Your
to take into
Lordship.
consideration their
After they
objection also.
file the reply.
Discretion ultimately will remain with the court. Hmm? There is no separate order sheet for this case. Huh? This is placed below. Okay. So you'll file an objection or not?
We will file an objection. We just need some more time because the petitioner resides somewhere in East Garo Hills in Sogadam village, and it's very difficult for him to travel. So we're just waiting for his signatures, Your Lordship, in this matter.
Okay. The miss case, just pass over the miss case. You are Arolindo.
Arolindo, yes.
Mr. Arolindo. Non-counsel, appearing for the respondent. Place for grant for some more time. For filing an objection in the matter. We'll just let it remain, we'll not say at last chance. Just say prayer allowed, list after 2 weeks. And then in the main read petition also, list after 2 weeks. Just say list after 2 weeks.
Item number 4.
Yes.
Lordship, we are yet awaiting instructions in this, Lordship. We have not received our instructions.
What is the instruction? What is the order?
But they were required to seek for an instruction regarding the notification which provides for 4% reservation.
Okay.
Because here, my lord, the appointment was made of 54 candidates. Now, even if you take 4% of 54, it comes to 2. My lord, in this present case, my lord, there were only 2 candidates who were under disabled category.
So you want to say that if it is 4%, then you will get the job?
Yes.
You are entitled?
Yes, my lord. To that extent, there were...
If it is 3%, then you are not getting.
No one.
And they were needed to take instruction on that, whether it is
Yes.
3% or 4%.
Yes.
This appears to be a small thing, Mr. Thawa.
Yes.
Then why it is taking so much of time? Anyway, we'll...
Praying for 2 weeks' time, Lordship.
We are on 17 now.
Yes, Mr. Thapa, we will give them some time.
No issues, my lord.
Because there is no other option also.
Yes.
Okay, Mr. Thapa, learned GA, appearing for the state respondents. Praise for grant of some more time. for obtaining necessary instruction. As per order of this court. The counsel appearing for the petitioner has no objection. Prayer allowed. List after 2 weeks. Have the instruction.
Yes, Lordship, we'll do that.
If they are entitled, then we can finish the matter there.
Yes, Lordship. Highly obliged.
Item number 6.
May I please, Your Lordship?
Yes.
Your Lordship, in this matter, I am replied 2 weeks' time, Your Lordship, to file rejoinder affidavit.
Rejoinder affidavit.
Yes, Your Lordship.
Against what? Against whose affidavit you will find
Affidavit
rejoinder?
filed by the state, Your Lordship.
State has filed affidavit when?
Yes, sir, Your Lordship, on the 8 March 2024.
This is a matter which went up to division bench and then again came back.
No, Your Lordship.
This is not the one.
No, Your
Then why it's a 2019 matter, isn't it?
Yes, Your Lordship.
So why it took so long for the respondent to file an affidavit in opposition? Who is appearing for the respondent?
Sir, KP Bhattacharya.
I'm being led by Mr. Bhattacharya, Lordship. We filed the affidavits.
You filed the affidavit. Why you filed the affidavit so late, madam?
Lordship, the matter had changed a lot of hands.
Hmm?
The matter had changed a lot of hands.
You are not audible. This is response number 4 is the state. See, this is an affidavit filed on 8th March.
That is by the state, my lord.
Response number 4.
Yes.
Who are the other respondents? Who are 1, 2, 3 or who?
1 to 4, Your Lordship.
State is what respondent, madam? Who are the number 1, 2 and 3?
1 to 4 is the state, Your Lordship.
1, 2 and 4.
All are state respondents. So why this affidavit is only on behalf of the respondent number 4? Yeah, your synopsis is longer than your writ petition. There appears to be private respondent also. Respondent number 5.
Yes, Your Lordship.
Nobody is appearing for respondent number 5.
No, Your Lordship.
Well, please check the office notes properly. Maintain your records properly. Otherwise, these small things causes problem. Last week we detected that this court carried on with passing of wrong order because of wrong submission of a lawyer for almost 1.5 years. So that is what the problem is. Court has to be careful before passing any order. Cannot just go blindly by what lawyers submit. That is what the problem is. And especially when you find that the state counsel is not there, then neither nobody is holding the file also. It's a problem. This is an affidavit in opposition only on behalf of respondent number 4.
Yes.
Not for the entire states or respondents. It says that on behalf of the respondent number 4 in the opposition petition. Not of these things. Anyway, you want to file a rejoinder against this?
Yes, Your Lordship.
Okay, Learned Counsel. There is any other order allowing you that? Allowing you the permission to file a rejoinder before? No.
No, Your Lordship.
You are making this prayer for the first time?
First time, Your Lordship.
Okay, Learned Counsel, the petitioner. Praise for grant of some time. To file the rejoinder against the affidavit in opposition filed by the person number 4. How long will it take?
2 weeks time, Your Lordship.
Prayer alert. At least this matter after 2 weeks.
Much obliged, Your Lordship.
Item number 12.
May it please, Lordship.
Yes.
Lordship, the crux of the matter is that the petitioner was a director of Seven Sisters Plastic Private Limited. When he was a director, actually he was a managing director, in fact. And the company took so many loans. In one loan, Lordship, the petitioner has mortgaged with this Banihad branch of State Bank of India. What happens, Lordship?
Mortgage what?
Equitable mortgage, Lordship. So that loan was ultimately liquidated. Thereafter, Lordship, he wanted back his documents. Meanwhile, what happens? The respondent had filed one criminal case, complaint case. In that case, the learned CJM.
Who is respondent?
Respondent is.
You have taken loan from the bank.
Lordship, what happens?
You elaborate it. See, you know the facts. So until and unless
I'm going to explain it. Lordship, what happens? I was also a director in the company where the respondent is also a director. I was the managing director of that company. While I was there,
so both are part of
that company. Yes. Now, Lordship, in one of the loans with Banihad branch of the State Bank of India, I mortgaged my properties to secure the loan for the company. And that loan was ultimately liquidated. Thereafter, in between, something happened, Lordship, I will come to that later on. Substantially, when the loan was liquidated, I wanted back my documents from the Banihad branch. The mortgage is, as the loan is liquidated now, the mortgage documents may be returned. That is what is one fact. Meanwhile, the bank informed me that no, because there is an order of the criminal court, and it's CJM, revolt, that the document may not be returned to the petitioner.
Can a criminal court order that?
That is the thing, Lordship. That is why I am before your Lordship. Now, what happens? The reason for this is that there are inter-se disputes between the respondent and the petitioner. I was ousted from the directorship, but my loan remained.
No, but then you said it is loan stood liquidated.
Loan was liquidated.
Then?
Loan was liquidated. Then? But for this dispute, Lordship, they have filed one criminal case.
Against you?
Yes.
Lordship. Under what section of law?
These are
what is the allegation against you in that criminal case?
I have misappropriated money. I have, Lordship, not used, misused some LIC policies, given as security in connection with some other loans, etc., etc.
In other loans, not pertaining to
not pertaining to this. This is liquidated. Loan clearance certificate is also there before your Lordship, and thereafter the bank had said.
Bank is a party here?
Bank is not a party. Neither there nor here, Lordship. Bank was not made a party. That is the thing, Lordship. Like a bolt from the blue, I am shocked when the bank refused to return the documents. Lordship, in that connection, what
But
happens?
then once you are out of the company, whether it is returned or not returned, which way it matters is.
Lordship, what happens? Because my personal property.
You did not mortgage anything in your personal capacity. You did not mortgage your own personal property.
Personal capacity, Lordship.
How can it that be? If you obtain loan on behalf
Loan
of
was
your
for the
businesses,
company, Lordship. Loan was for the company. I, as a personal guarantor, to secure the loan for the company, being a
can there be? You are an employee of the
no, Lordship.
company, isn't it?
No, Lordship. Anyone can stand as guarantor. If
that is okay, but then normally that is not the practice, is it?
No. Normally, Lordship, in fact,
until unless you own a business institution, okay, it is understood.
That is
but then
there.
here you are not owning it. You are not the proprietor of the business.
I am not the proprietor.
Then?
But even then, a third party mortgagor as a collateral guarantor, Lordship, he stood as a guarantor.
You are a part of the company, so you are obtaining the loan that way. Anyway,
Lordship, because of that order, Lordship, that order was also passed on the application of the respondent, Lordship, before the learned CGM.
yes.
And the learned CGM passed that order without actually giving us any opportunity of hearing.
The order was passed by the CGM.
Passed by the CGM.
Asking the bank not to release the documents.
Not to release.
Where is that order?
That is, Lordship, at Annexure 2, page 27 to 30, Lordship. Type copy is at page 29, Lordship, because it was very minute. Got it, Lordship?
Yes.
Lordship, I am reading it out.
Yes, please.
CR put up today, along with the petition number 19 of 2014, dated 10 to 2014, filed by the petitioner against the, petitioner complainant, the present respondent, Lordship, Brenninge Sangma. Seen and perused the said petition, wherein the petitioner complainant has stated that accused is trying to take back.
It was a complaint case. It was a complaint case.
It was the complaint.
Complaint directly.
It was the company, Lordship. He was on behalf of the company filed. Lordship, I will come to the affidavit later. Anyway, I am just finishing it.
Yes.
Submitted as an additional securities to the net fee, which is in no connection with this, and Ganeshguri, Guwahati, for a term loan of rupees 4 crores and rupees 3.4 crores with the State Bank of India, Barneyhat branch, in addition to land mortgaged by the complainant as a collateral security. Here, Lordship, land mortgaged by the complainant. That is, in fact, company. In fact, that company. But I was standing as a collateral surety by securing my personal properties, Lordship.
Go on.
Collateral security. The petitioner complainant also states that the accused opposite party has misappropriated, diverted the funds of the company for which this instant case has been filed against him under various sections of IPC. So the petitioner complainant is afraid that once he succeeded in taking away the original documents deposited as the additional securities, the company, Messrs. Seven Sisters Plastics Private Limited, will incur a heavy loss, as the accused has diverted huge amount of money during his term as director. Therefore, he prays before the court to direct the said net fee and the State Bank of India, Barneyhat branch, not to allow the present petitioner, Lordship.
How criminal case be filed for procuring this kind of direction? How a criminal court entertains? What is this petition is filed under what section of law? The criminal case on the presentation of the complaint. Now, how the court took cognizance of that? Did you get a notice before this order was passed?
No, Lordship. In my para 7, I have categorically stated, Lordship.
Seems to be unheard of a criminal.
Exactly, Lordship. That is the reason why I have come for protective hand.
That is okay, but then this is order is of 2014.
That is one aspect.
2024.
Because 2014, Lordship, what happens? I was not aware of this order at all till the bank has informed me that there is an order from the criminal court.
Where is the complaint? Which one is the complaint present?
Complaint, Lordship, just before this. Annexure 1, perhaps, Lordship. Yes, Lordship, Annexure 1.
That is the complaint presented?
That is the complaint petition, Lordship. Same thing, what has been reflected in that order,
Let
Lordship.
us see the prayer. What is their prayer?
Prayer portion is at Lordship.
There is no prayer.
I'm coming. Just a minute, Lordship.
No, there is that appears at page 26. Come to page 26. I think that is the last paragraph is their prayer.
Yes, Lordship. 21, page 26. These are the sections quoted, Lordship, directing the police under section so and so to investigate the matter, etc., etc. That was registered as a complaint later on.
And then what is there to the order of issue of process?
Issue of orders.
Process. Before a criminal court, what you were reading just now, it seems to be final order by that court. Now, upon complaint,
final means, Lordship, that is interim in the sense that was.
Okay, let us say it's all right.
Okay, Lordship.
But then what is the initial order passed?
No order, Lordship, as yet. The case is pending.
Can a court, without complying the provision of section 200 onwards,
that is what is not understood, Lordship, at this end.
Process in a criminal case and pass subsequent order?
That is the thing, Lordship. That is what is not
You
understood.
don't have to go to the facts. Okay, but then one thing appears to be is that 2014 order. Now, definitely it is barred by limitation. You cannot come and challenge it here, right now.
In a sense. Meanwhile, Lordship, when we came to know, we filed an application before the learned sessions. CGM court. No. Revision was there, no? No, that petition was there. We have filed the subsequent petition that was also rejected. When we came to know, we filed another application that is there.
What was the petition you filed before CGM court?
Annexure 4, Lordship. Page 36, Lordship, may come to.
Page 34.
34, Lordship.
Page 34.
56 or 36? 36, Lordship. 36.
This you filed before a.
Yes, Lordship.
The procedure of law has been given a total go by, you see.
Lordship.
Why you did not challenge it before session judge? You have challenged, have you?
Huh?
What is this order passed by this civil judge
in
at
this
Guwahati?
That is, Lordship.
Come to page 31, annexure 3. What is that?
31, Lordship.
Page 31 of your petition. What is that? There appears to be a title suit, order passed in a title suit.
In a title suit, Lordship, that was a prior suit. That was a prior suit, wherein that is between bank and the present petitioner, Lordship. In connection with that loan.
You are Dinesh Kumar Mittal.
Yes, Lordship.
Now there, it seems that you are the plaintiff.
Yes,
yes. And what was your suit for?
Suit for declaration, Lordship.
Is it in connection with that same loan which you say
Yes,
that is
Lordship.
liquidated now?
Yes, Lordship.
What order was passed in this civil case?
Suit is also pending, Lordship. Suit is also pending.
No, suit. What prayer you have in that suit?
In that suit, Lordship. For declaration key as plaintiff.
Which way it is connected with this criminal case? Present connected?
Otherwise not connected, Lordship.
Then why you have appended it here?
No, Lordship, what happens, the bank informed when the document was prayed for, it was prayed for to release the documents, Lordship. The civil court also passed that as there is an order from the criminal court.
Then how that suit was filed in Guwahati? Outside the territorial jurisdiction of this?
That is their Khanapara branch.
See, your criminal case is in Meghalaya, your civil case is in Assam. How can it be?
That is, Lordship, because the head office is there, Lordship.
Do not know. There seems to be you have procured loan from the State Bank Khanapara branch.
Khanapara branch.
Then what it has to do with the head office, where the head office is situated? The jurisdiction has to be there only. And that in that suit, bank is a party. The present respondent is not a party.
Lordship, one more thing, Lordship. Yes, sir. Party, yes. Bank is a party.
Yes, Mr. Sangma, you were a party before that suit in Guwahati?
Pro forma respondent, Your Lordship.
Pro forma respondent?
Yes, Your Lordship.
What is the status of that suit there?
It is, now it is in the process of evidence, Your Lordship.
Is it pertaining to the release of the...
Yes, in one of the prayer, they said in the civil suit in Guwahati, Your Lordship, declaration that the plaintiff are entitled to receive back all the original document with respect to Schedule 1 and Schedule B.
So it is more or less the same thing?
Yes. They have prayed for release of the document.
Yes. Now which case was filed first? This civil case or the criminal case?
Civil case 2014.
So then thereafter, how could you file a criminal case before the court in Longpo? And under what procedure of law this court has proceeded?
Because, Your Lordship, in fact, for the present, they should have got this order from the civil court Guwahati, Your Lordship.
No, how a criminal case is filed? How it processed?
Criminal case is filed because...
how the court took cognizance of the complaint filed by you? If the taking of cognizance is wrong, then the entire thing will be wrong. All the subsequent order will go. You can sit down for just procedure. We'll come back to you. Just have a seat. Let him just primarily satisfy how that process was issued in the current case. You just show us that these orders were passed, or the criminal court had the jurisdiction to pass this kind of order.
This criminal court is, if I look to this Annexure 1, Your Lordship, it is before the filing of civil court.
No, this order which has been read out just now. Okay, passed by this CJM Longpo.
Yes, Lordship.
That how the criminal code exercises this kind of jurisdiction and under what law? How a criminal court can pass an order of injunction? Just tell us. Except in matters like 125 and all those things, passing interim order, you have to satisfy us. Why you have not made bank a party?
Lordship, in fact, because of that criminal case, in the criminal case, the bank was not at all a party. We have filed, no doubt, for release.
We understand, but then there appears to be a civil case.
Yes, Lordship.
Now, we do not know what order has been passed in that civil proceeding, which according to the learned counsel for the respondent is pending. Now, this court cannot pass any order interfering with the order passed by the civil court situated in another state. This will be beyond territorial jurisdiction of this. Now, so far as this court is concerned, it can confine itself only to the criminal matter. But then, you see, like if you say these are again interdependent, and you approach this court, say almost after 10 years, which is 2014, now it becomes very difficult if this court wants to give you some relief also.
Lordship, we have been, in fact, not only non-suited, we have been made remediless because of that, because the loan is liquidated, because
Civil matter is pending. So once you get a direction passed, they're finished, or matter is over.
Matter is over, dear lordship, but
See, basically what you should have sought the quashing of the entire criminal proceeding without going into anything, and then allow that civil
there
case
are
which
other
you have
things.
filed,
There
allow
are,
it to proceed.
there are other things also they have claimed there, LIC, etc.,
The
etc.
fact remains we are.
If we confine lordship,
we are exercising.
Page 33 lordship.
Yes.
What happens? They have filed one application in the civil court. Bank has filed. Lordship, page 33, para 6.
Yes.
Complaint petition. In our petition, Annex 3. Para 6 lordship, that although the loan account of the defendant number 7 has been liquidated and the defendant has issued no due certificate, it is not possible for the defendant number 1, 2 and 3 to release the security documents in favor of the plaintiffs in view of
That is a stand taken by them. That stand will not bind you. The civil court will be definitely superior so far as these matters are concerned. The criminal court's order will not bind you.
Not binding.
That is the law.
And that is the reason, again, lordship, so far civil court is concerned, lordship, I am not before your lordship because it is within the Guwahati jurisdiction, Kamrup Metro. But this, so far the bank is concerned again, so far the bank is concerned, that is within the jurisdiction of this honorable court. And the criminal case is also. Lordship, the criminal court, learned criminal court has passed such an order, lordship, which is in fact not sustainable in respect of interfering with a contractual matter. When the loan contract was, that the loan was liquidated and the contract was over, lordship.
That is the second part. They were coming to merits. Definitely
Lordship,
you are correct.
lordship.
You are correct there. But then here the way criminal court proceeded, it has not even, you see, followed the law which it is bound to. See, like basically taking of cognizance by a magistrate
has already
is not a matter of force.
Yes, lordship.
Law requires certain thing to be fulfilled.
Completed, yes, lordship. Fulfilled.
And then before issuing a process, court must satisfy that they are exit prima facie. And especially when the accused is out of station, then that adherence to section 202 also becomes compulsory. That court before issuing process must inquire in investigation. Direct for one inquiry either by itself or tell police officer. So it seems nothing of that sort. It is something like that. You see, like you file an application before a court and say, please you do it, and court also went up passing, and then you also responded to, you file your shokos there, this and all. You should have directly challenged this taking of cognizance by the criminal court. It is not that they only have initiated wrong. You have also followed a wrong process.
In that case, lordship, what happens? Some other things are also entangled, made entangled.
What are the other things entangled?
Other things means, lordship, loan from the net fee, loan from UK bank, etc., etc.
Doesn't matter. See, these are all factual aspects. How criminal court do not know. Then did you approach?
That is your lordship has ample jurisdiction, lordship. In one sense.
Question is you are coming after 10 years, Mr.
After 10 years means, lordship, we have come after.
A position which is settled cannot be unsettled at this stage. Delay defeats equity.
That is true. Dear.
So
that is true. Lordship, what happens? Meanwhile, we have filed a criminal revision also. That is another order, lordship, which we actually.
Criminal revision.
Lordship.
Where?
District and Session Judge, lordship.
District and Session Judge.
District and Session Judge. No.
Nanko. Where is that criminal revision?
19 lordship. Annexer, page 45. Annexer, কি নাম আছে? Annexer 6 lordship. That order was 45.
40?
Page 45.
45. There is a copy of the criminal revision petition, isn't it? There is a judgment.
Lordship, judgment. Here, Lordship, the same thing. Your Lordship has also raised that 10 to.
That is a case of 2019. So you preferred a revision after 5 years of the passing of the.
Because of want of our, and we have, after we have faced all this, faced with all these.
And that was entertained.
Entertainment.
Without it was beyond period of limitation.
We were actually not aware a lot.
Beyond period of limitation.
Against that 19 order, when we came to know, Lordship, 2012 order was there. 2019, we have filed this when we came to know. Annexure file.
That is all right.
That is there.
But then there are certain procedures to be followed there. You have should have taken recourse of this limitation act, whatever, whether under section 5 or section 14, that is up to your thing.
Lordship.
Okay. But then how can a criminal revision petition be entertained after first lapse of 5 years?
From the date of
From the
knowledge.
passing of the impugned order, that also, because you see, there was earlier, the law of limitation was not applicable in the state of Meghalaya. Now it has been made applicable throughout, pursuant to a judgment passed by this court. Okay. So that is where the thing is that. So it seems nothing has gone in accordance with law. You know that the illegal action in taking cognizance, then the challenge to that also by in illegal way. So what happens?
Lordship, actually, we have also come under Article 227.
And what is the order passed by this revisional court?
Revisional court passed that order. That previous order still stands if we challenge the subsequent order when we made the application before the learned CGM. We made subsequently the application before the learned CGM that we were not aware of that order. That order was passed behind our back. Now that order may be vacated. Then, Lordship, it was again rejected after coming to our knowledge. Then we had
to come to that order passed by that court. Come to page 52. Page 52 of your petition. Page 52 of your petition. Read paragraph 12.
Paragraph 12, sir.
Yes.
Counsel for the respondent has informed this court that the petitioner has instituted a title suit for recovery of the original documents that we have already shown, Lordship, from the bank, and the same is still pending before the civil judge, District Kamrup, Assam. Therefore, this court has formed opinion that no matter relates to the release of the original documents from the bank, which shall be based on the outcome of the civil suit, or upon any direction issued by the civil court. At this stage, while considering the issues involved, this court is of the opinion that the liberty for releasing the original documents to the petitioner shall be at the discretion of the concerned bank. At that point of time, Lordship, the bank has said.
No, just complete the reading. See, that serves your purpose.
Shall be, yes, Lordship. Liberty to release the original documents to the petitioner shall be at the discretion of the concerned bank when the bank realizes the loan amount from the outcome of the civil court.
So,
with the above.
So whatever your suit is filed by you, so whatever decision you obtain in that civil court, that will bind the bank. So matter goes, you have your relief there. You see, expecting this court to interfere with the order passed 10 years back.
That is their Lordship.
That is something.
Because I was somehow misadvised, or.
We can understand that the process initiated is totally illegal.
I understand. That is the reason why.
But then once this order interpreted the situation and saying that the civil court's order will bind the entire situation, that is good enough. You should not have any more grievance now.
Otherwise, Lordship,
that is your suit.
Another thing, Lordship, the bank is also insisting that in view of the extent order of the learned.
Bank is not a party here.
Bank is not a party, but.
Then we are not concerned with the bank. What bank wants or bank doesn't want, we are not at all concerned. We are concerned with the relief which you are seeking here. Now, admittedly, there appears that you have filed a civil suit which is pending disposal,
That's it.
and this criminal court's order says that whatever the outcome in civil court, that will basically decide the situation. The matter is over. You get your relief. Wait for outcome of your civil case.
That is correct, Lordship, but
Only thing is that you see,
otherwise-
we could have interfered with the entire initiation of the criminal proceeding if you had approached the court. But then after these orders are given effect, then what do you expect now?
we are otherwise also we are helpless because Lordship.
Now say supposing if you interfere
we have
with
been
this
made
order,
remediless.
if you interfere with the orders, and if you set aside this order passed in criminal revision also, that means the order by which say that civil court's outcome will decide the matter, that also will go.
Otherwise, that is binding on the criminal court. But whether actually when the matter civil suit was pending, the learned criminal court ought not to have passed this order, Lordship. That is the reason, perhaps.
Now, are you seeking setting aside of the order passed by that revisional court also? This order?
Yes, Lordship.
Then if it goes, then what happens? Then what will be the consequence there?
That is another
Can
thing.
it be interpreted that way that civil court will not have the authority
Yes,
to
Lordship.
decide?
Here the liberty granted.
So think over, you see, you should have given a thought on that. Here, you not know, you see, like, seems it's a mess now. So. Yes, Mr. Sangma, how do you justify your filing of the case?
Because of the fact of the case, Your Lordship, because according to the fact, the petitioner is the director of the plastic private company, and the respondent has given him 11 LIC document.
You are coming to facts.
Yeah.
This court at this stage is not much interested to enter into all those things. Honestly, in this sitting in a matter under 482, we cannot go much into all those things. Now tell us which way this criminal court took cognizance of your complaint and issued process without following the process of law under section 200 to 204. Just tell us.
I hope, Your Lordship, the trial court has followed certain procedures.
Just show us some orders. Follow what is the process.
I don't have in my hand.
If you want this order to remain there, otherwise
Your
it
Lordship,
appears,
this,
of course, there is fault on the part of the petitioner.
Yeah.
They have approached this court after a delay of almost 1 decade.
But this, Your Lordship,
but then
at this
that would not basically attach legality to your action. This entire exercise of jurisdiction by criminal court seems to be totally arbitrary.
Yes, Your Lordship. But Your Lordship, this case, this
yes, sir.
Criminal,
Please sit down. Sit down.
Yes.
Let him.
This criminal criminal revision does not have any merit to be taken by Your Lordship at present. The reason is that the case is still pending in the court of CGM. CGM has taken, and it is still under process by the CGM because he has filed a criminal revision petition, and the court of district and session judge rightly stated that the petitioner has not appealed against the order of 2014, setting aside the order of the.
It's not regret. This order is passed without any jurisdiction.
So,
what validity it will carry with you? You just come to your complaint petition. Come to page 21 of this criminal revision.
Yes, Your Lordship. Yeah.
Cast page 21.
21. Yes.
See what address of the accused you have given.
This is before the. It is not the deputy commissioner. Yes, Your Lordship. He has narrated all the facts.
No, the address.
Yeah.
Of the accused.
Yes.
It is outside the state.
Yes. Yeah.
Yes. So tell us which way a process was issued to an accused who is residing outside the state without following the provision of section 202 CRPC. Was there any investigation or inquiry conducted by the court or directed for any investigation by the police?
That one I need certain facts
See,
to answer.
probably
Your
what appears from the documents attached here,
yes,
that the proceeding initiated by you
yes,
is without any sanction. It should have been quashed then and there.
yes.
Okay. Now the main problem for this court is that now will it be proper for this court to interfere with an order which was passed 10 years before? Because they have approved, they have come only after 1 day. What do you do in this situation? Tell us. This court doesn't
In
know
this
anything.
situation, Your Lordship, this case, this honorable court may refer back to the district court, and that is.
What refer back? This court, if interferes, it will interfere the entire proceeding. Then what is to where it to be referred back?
If it is referred,
which
then
court it will be referred back?
Then their case which is pending in
See,
the
admittedly,
court.
there is a civil suit pending. You are also a party there with the bank.
Yes.
And this criminal court has passed an order that whatever order is passed by the civil court,
Yes.
that will be binding on all the parties.
Yes, definitely, Your Lordship.
So let this all the order passed by criminal court go, and just wait for the outcome of the civil court. It has become a mess, Mister.
Lordship. Lordship.
You have also contributed to that.
Yes, Lordship, because so
You
many
were
things.
negligent right from the beginning. See, it may be one thing that you got notice from the criminal court later, but then thereafter also you succumb to the jurisdiction of that
It could
court.
not
You
be
appeared there,
reconciliated.
You filed a petition there. You have not challenged the jurisdiction of that court,
Lordship,
and basically encouraged that court to pass some order.
because when Lordship this order was passed, page 33, Lordship, I had already.
Can you say you are stopped by your conduct? You cannot challenge it now, because since you have succumbed to the jurisdiction of a criminal court. Can estoppel operate in jurisdictional matter?
Lordship, oh, what should
You
I
have to
say?
tell us with this. You have to enlighten the court.
Lordship, we could not reconcile what happened earlier. Somehow, Lordship, ultimately, substantially, the original thing was, in fact, an illegal order. And we are now.
Entire things will be
Lordship,
illegal.
Lordship, I agree
Their
with you,
criminal
Lordship. I agree with you, Lordship.
Initiation of the criminal case by the illegal. Your revision after 5 years without filing any petition under Limitation Act.
That has also been
illegal. You do not know. Once it is barred by law, how this court could take cognizance of that.
At present, Lordship, we have come.
So, which order will prevail?
That is another aspect, Lordship. Rightly, that is another aspect.
And now perhaps you do not make this court to pass another illegal order.
That is the thing, Lordship. This could not be reconciliated. I have already submitted before your Lordship with all humility. I have been sent from pillar to post, Lordship, because of that order.
No, not at all. You are not at all sincere. If you were, you could have
Straight,
got your relief at the very beginning. There is evidence of negligence on your part. Otherwise, you will never challenge an order after 5 years.
Lordship, may I submit because of Article 227, Lordship may exercise that.
We understand, but then one thing is that though we have made some observations, but then there appears to be. Do you have, Mr. Sangma, do you have any copies of the order passed by the Court of Magistrate before initiation of the before issuance of process? Because without knowing that also, it will not be proper to pass anything
We don't
on
have
the basis of presumption.
Before taking cognizance.
You have, yes,
I
at the
don't
time of
have
taking
your lordship.
cognizance and all. Can you furnish those copies, or Nobody, now you do not have in your
We do not
record.
have, Lordship. The case is still not.
Then this, you see, like this thing will become
We can
probably easier for the
We
court.
may also procure, Lordship, if your Lordship permits. If your
No,
Lordship
permits means like you just think we should, because otherwise one thing is that, you see, that question remains that you have approached this court after 10 years.
That is true, Lordship. That is
And
true.
even if you
It is
take into
undeniable.
consideration of passing of the order by the, when this revisional court passed the order?
Which order, Lordship?
Revisional courts, what is the date of the
court's
part?
order was
19.
28 to 2023.
So after that order,
After that
you
order,
are not that late.
not that late, Lordship, but that order also, your Lordship has already pointed out that point key.
Mr. Sangma,
Yes, Lordship.
you would like to produce the copy of the order by the trial court, or you want this court to pass
I
some
will
order?
try,
at this stage?
Lordship.
We don't think we can. We have to interfere with the order passed by the trial. Maybe by the revisional court also. But then we do not know how they are affected by the revisional court's order.
Is this okay? The date is not there.
And if you can show us something that inordinate delay on their part, they are not entitled to enter.
I may try, Your Lordship.
Otherwise, what defense you propose to make at this stage? We will not go into the factual aspects which you are trying to place before us.
Yes.
Will not. We are. This court is not at all interested.
Give some more time to try to obtain.
I think it would be better if you have a copy of the trial court's order.
We will also try, Lordship.
And at the same time,
Lordship.
how long it will take you?
1 month, Lordship. 4 weeks. Same thing, Lordship. But normally court grants time in terms of weeks.
No, just say, are the learned counsel for the
I
parties?
will have to come to again, Barneyhat.
It appears from the materials on record for proper adjudication of the matter. Placement of the initial order of the court of the CGM in CRP number 2 of 2012 is necessary. So, both the counsels appearing with the parties pray for grant of some time, enabling them to some time to enable them to procure copy of the orders passed by the. It was CGM order was by
CGM, Lordship.
Somewhere it is
Initially by JM, Your Lordship. Then later on taken over by CGM.
But then in the order sheet it is written both CGM and assistant to the Deputy Commissioner.
ADC.
Achha, assistant to DC for civil matters. What is the last line? Just them. Not a copy. Copy. To procure the copies ordered passed by the learned CGM. Again, see, there are two case numbers reflected at page 27. Just see.
Renumbered, Lordship, 2 and 5. Separately, one was.
These are same matters.
Same matter, Lordship. 2 and.
Earlier it was 2, there was renumbered as 5.
2 of 12.
Just last line, just see.
5 of 13.
by which issue of process was ordered against the petitioner hearing in CR case number 2/2012, then within bracket you write renumbered as CR case number 5 of 2023. Then give paragraph. Say in view of the submissions made. Oh no, just say the prayer made. We've been needing 4 weeks time. Before that cannot be done.
Lordship.
See, anyway, this
As your Lordship pleases, Lordship.
we'll give you 3 weeks. You see, like longer the gap, the court forgets the thing. Then you have to again place the matter before the court.
Lordship.
We'll give you 3 weeks.
3 weeks.
3 weeks.
Let us see, Lordship.
Give it a try. If it is
Yes,
prepared,
yes,
then we'll
Lordship.
extend that.
Let us see. Let us see.
That in view of the submission made, list this matter after 3 weeks. Meanwhile, the parties shall try to procure the copies of the order passed by the trial court and place it before this court for the next date of hearing.
Deeply obliged. Deeply obliged.